Kip and Marilyn Dunlap own a small quarter-acre vacant residential lot in the city of Nooksack, just south of the Canadian border in Washington. They plan to build their house on that property, but the problem is a small stream runs through it, Nooksack Slough. Not a problem, there's plenty of land. The problem is with the regulations. You see, the city of Nooksack adopted 50-foot buffers on all area streams. These buffers made most of the Dunlap's property undevelopable. So for a period of years, the Dunlaps filed application after application trying to figure out what, if anything, could ever be built on their vacant residential lot. At the end of the day, nothing reasonable could be built. The city said the only way it would grant them permission to use their property would be if they built a small house, no more than 480 square feet in size, triangular in shape, raised on stilts. They wouldn't even be allowed to have a driveway, a garden, or use their yard, build a fence. Nothing. Just a triangular shack on the side of a stream. Well, the Dunlaps refused to accept these conditions on their land, and they sued the city for inverse condemnation. The trial court agreed with the Dunlaps and found that the city's actions had taken their property without just compensation. The city appealed, and this is when PLF got involved. You see, the city was arguing that its stream buffers were environmental regulations and that environmental regulations should trump the protections of the Constitution. And we all know that that is just not true. That the Constitution protects a property owner from having all economically beneficial uses wiped out by government regulation regardless of its purpose. PLF filed an amicus brief with Division 1 of Washington State Court of Appeals arguing that the Dunlaps had been deprived of all economically beneficial uses and that the purpose of the regulation, the purported environmental reason for imposing the buffers, was irrelevant. The Court of Appeals agreed and held that if the city wanted to turn the Dunlap's property into a buffer for public use, it had to pay for it. The decision's name is Dunlap v. City of Nooksack. And this decision comes at a very important time because cities and counties across the state, indeed across the country, keep expanding their environmental and other land use restrictions, seemingly without end. And it's very important that our government know that there are limits to what it can do to private property, and that the Constitution will protect a property owner when their rights are being imperiled by these regulations. For more information about this case, please visit PLF's website, www.pacificlegal.org.